right, we're going to trial on our first case. Go ahead and make your announcement, counsel, with the cause number and the case name.
Cause number DC 19-00870, the Bank of New York Mellon Trust Company, N.A., as successor in interest to all permitted successors and assigns of Bank One National Association as trustee of the Greenpoint Manufactured Housing Contract Trust, pass-through certificates series 199-5, plaintiff Lafitte 8 R. Roan, Jr., Mary A. Roan, and are all occupants of 12 Oakdale Street, Wilmer, Texas, 75172. Jeffrey Lewis for the plaintiff.
Let's proceed.
Your Honor, this is a suit on a replevin action to recover possession of a manufactured home located on the address 12 Oakdale Street, Wilmer, Texas. The defendants entered into a retail installment contract on August 28th, 1999. A copy of the contract is Exhibit E in the statement of evidence. The certificate of ownership is attached to the business records affidavit, as are the notices of default on January 16th, 2018, the notice of acceleration on November 20th, 2018. Loan payments are due for January 2nd, 2018 through June of 2020. As of June 26, 2020, the amount owed on the contract, including principal, interest, and other fees, was $52,647.33, with interest at the rate of $7.86 per day. In addition to the business record affidavit on file as in our statement of evidence is the return of service on Mary Roan, the return of service on the occupant, the statement of ownership, the notices of default, the notice of acceleration, and the notice of transfer of servicing of loan to Shell Point Mortgage Servicing. Your Honor, with that, the plaintiff rests.
All right, just so I want to make sure I'm understanding this. So you're offering which exhibit numbers? Because we haven't gotten them yet. Did you also email
the exhibits A, B, C, D, E, F, G, H, and I were filed with our statement of the evidence, and those are on file with the court.
Okay, why don't you just let me finish so that I can kind of ask the question. I apologize, Mr. Lewis. So two things. So you emailed the court coordinator the exhibits. Did you also email the court reporter the exhibits pursuant to the emergency order?
I'll have to check with the paralegal that was doing the emailing.
Tony, did you get that exhibit yet?
No, Judge, I have not yet.
All right, so I want to make sure this is done correctly, Mr. Lewis. So can you go ahead and email my court reporter all the exhibits so that she has it for part of her file, because we want to make sure this is done correctly?
Yes, Your Honor. My paralegal is on the line, is on this call, so she's hearing us and she will email.
Tony, can you go ahead and just put in the chat what your email address is?
Rhonda usually does that for me. She'll do it.
Okay, Rhonda, go ahead and put that in the chat for me.
So I just got a message from her that she's emailing it to the court reporter now.
And just so the record is completely clear, so you've filed a statement of evidence in the clerk's record, correct?
Correct.
You're also offering exhibits for this trial, correct?
Correct.
And what are the exhibit numbers you're offering for the trial that the court reporter should have marked and make sure it's part of the record?
Exhibit A is the retail installment contract.
Okay.
Exhibit B
Exhibit A is admitted.
Exhibit D is the certificate of ownership of,
Exhibit B is admitted.
thank you. Exhibit C is the notice of default.
Exhibit C is admitted.
Exhibit D is the notice of acceleration.
Exhibit D is admitted.
And in the affidavit is the sworn statement of the the keeper of the business records as to the outstanding balance.
Is that Exhibit E?
No, sir, it's in the affidavit. It's in the body of the affidavit.
And the affidavit is offered as which exhibit? Is that Exhibit A?
We'll have to mark that as exhibit. We'll have to mark that as Exhibit E.
E. All right, Exhibit E is admitted, but the version that you emailed, that your legal assistant emailed to my court reporter, does that have it marked as Exhibit E or not?
Hopefully it does. If not, we'll email another one.
Okay, I just want to make sure that we have the record clear. I'm not trying to fuss
understand.
with you. I just want to make sure that.
Yeah, I understand, Your Honor.
So, all right, so Exhibit E is admitted. And Tony, you should have now the email address for the legal assistant. So if for some reason there's some question about where Exhibit E is in the documents that you get, feel free to reach out to her. And if you can't figure it out, then we'll hold another hearing, but hopefully that won't be necessary. Is there any other exhibits you're offering at this point, Mr. Lewis?
No, Your Honor.
What is the relief you're requesting from the court?
The relief we're requesting from the court is an order of possession and a deficiency judgment for the amount, for the difference between the amount that's of the obligation and the amount we realize from the disposition of the collateral.
So, and did you submit a judgment for me?
Yes, Your Honor, we did.
Let me just pull that up and make sure I find the right one, okay? There's no Exhibit E listed. Can you go ahead and share screen what Exhibit E is supposed to look like so that Tony has it?
Yes, Your Honor.
Now, let me go ahead and activate that real quick. Are you share screening that?
I'm working on that.
Okay.
We
And
just-
I don't, oh, here it is. Okay, I found it. All right, so I found your judgment, so I'm going to go ahead and print that out.
All right, I have it up, Your Honor. And now I've got to figure out how to share it.
Okay, so there's a share screen on the bottom there. Do you see it? On the bottom of your... Am I sharing screen at this point, guys?
No, Judge.
Oh, here, I got it. Did it come up?
Yeah, it did. Okay, so this is what exhibit, that's the first page of Exhibit E, is that correct?
That is correct, Your Honor.
So,
And attached
Tony,
to the first page is the business records affidavit.
so the first page of Exhibit E should be the business record. Here, stop right now. Should be this page, correct?
Correct.
All right. So, Tony, that's the first page of Exhibit E. So make sure that that's marked as Exhibit E. Okay, the court will go ahead and admit, make sure, so it's clear on the record, exhibits A through E, and the court will also grant relief requested by the plaintiff in this case. And we'll sign a judgment and hopefully get it scanned in by tomorrow. So anything else, Mr. Lewis?
No, Your Honor, that's what we have for today. I certainly appreciate your patience with my technology or
No
lack
problem.
thereof.
That's okay. We're all learning, so it's no big deal. So you be safe out there, and
Thank you.
you are excused. Have a great day, okay?
Thank you, Your Honor.
Wait.
The exhibits haven't come in just yet. Has she already emailed them?
She says she has.
Okay, well, it's not on my, I don't see it just yet, but.
Okay, well, you need to, sir, go
Yes.
ahead and include your email address in the chat so that Tony has it.
Okay, sure.
Just in case she needs to reach you, and your phone number.
All right. I'm doing that right now.
Okay, we just want to make sure that we have a correct record.
I don't see Tony on the list.
You don't see Tony on the list.
On the send chat.
All you need to do is just put chat.
I did.
In the chat function, just put your email address and your phone number.
Okay.
You can just put it to everyone. You don't need to put it just to Tony.
I got it.
It hasn't come up yet, just so you know. Have you typed it in, sir?
Yes.
Tony, do you see it? I don't see it on, he may have sent it directly to you. I don't see it on the chat.
No, sir, not yet.
Would it be easier if you just told us?
Sure. Well, in my technology lack, I've typed it in, but I don't see a send button.
I don't know what to tell you.
He could just verbally tell me what it is.
Okay, thank you. It's jlewis@ravdocs.com. And it's RAVDOCS.com. By the way, it's on the pleadings.
All right, Tony, do you need anything else?
No, sir.
All right. Thank you, Mr. Lewis. You are excused. You be safe out there, okay?
Thank you, Your Honor.
All right. You have a great day.
Thank you. You too.
All right. We're going to go to cause number DC 1914872. We're going to do the same thing. Plaintiff's attorney is going to make their announcement. If you could state your name and the cause number and the case name, and then the defendant will state her name. So, Mr. Elder, why don't you go ahead and start?
Thank you, Your Honor. My name is Tim Elder. The case name is Unifund CCR LLC versus Carol J. Lack. Cause number DC 1914872.
Ms. Lack, please state your name for the record.
My name is Carol J. Black.
Okay. Let's go ahead and start with opening statements. Mr. Elder, you may start.
Thank you, Your Honor. This is a consumer debt case. It started out life as a Citibank credit card, which was purchased by Unifund. The defendant used the credit card to make purchases and she made payments on it until she couldn't anymore and stopped. So there is still a balance remaining on the credit card in the amount of $2,931.52.
How much again?
$2,931.52.
Okay.
Yes, Your Honor.
It's unusual we have those in district court, but that's okay.
If we could go off the record for just a moment, Your Honor, I'm working on that.
No worries. It's no problem at all.
Go back on
All
the
right.
record, Your Honor.
Are you done with your opening statement?
I do have one other point I would like to put on the record, Your Honor. The court gave us an extra couple of weeks to attempt to mediate and gave us an order to have it mediated by DRC. We have been unable to contact anyone at DRC until yesterday afternoon, trying morning and afternoon daily. And when we did contact them, it was a transferred number and they couldn't help us because they were working from home and couldn't access the Dallas County website. So we tried, but weren't able to.
Do you want to take, I can put you in the breakout room with Miss Lack and one of the interns or a couple of the interns, and do you want to try to work something out with her, or do you want to just go forward with the trial?
Your Honor, Ms. Lack has indicated that she's unable to do anything about it, so we're just ready to go to trial.
Okay. Miss Lack,
Yes.
you have your opening statements.
Yes, this debt was abandoned 3.5 years ago.
Mhm.
So I haven't paid anything on it for a period of 3.5 years. And I haven't filed bankruptcy or anything because I have been unable to afford to do that. But I mean, if there is a judgment issued in this case, then I would have to attempt that as a remedy.
Have you talked to them about doing a payment plan? That's what people
No,
usually
when we last met on, I think it was I don't remember what date. I want to say the 20th, but I think it was earlier than that. It was like 2.5 weeks ago. I indicated that I could not mediate, and you said that you would not force me to do that.
No, I said, have you talked about doing a payment plan with them, about maybe doing a payment plan?
No, I have not. I have not talked about a payment plan. I have not done anything in regard to mediation.
Would you like to I can put you into a separate room here and you could talk to Mr. Elder about a payment plan, or do you just want to go forward?
I don't see any advantage of doing that. I do not see any outcome.
Okay. All right, let's go ahead. Anything else you wanted to say, Ms. Lack, before we go into the evidence?
No.
Okay. Mr. Elder, go ahead and start with your case in chief.
Okay, thank you, Your Honor. As a threshold issue, Your Honor, there were requests for admissions included in the plaintiff's petition that were served on the defendant. The defendant has not responded to those requests for admissions. Those were therefore deemed admitted, as which an answer was not timely served. These deemed admissions are part of the plaintiff's original petition. We asked the court to take notice of that. These establish the liability of the defendant and the amount of the damages. We asked the court to deem those admissions and grant judgment in the amount of $2,931.52.
Okay, are you going to go ahead and, because of the nature of this, do you want to go ahead and admit the request for admissions as an exhibit?
Yes, Your Honor, please. That would be Exhibit 1.
Okay, and then did you also say you had an affidavit that you were admitting?
We have
or just the admissions?
Affidavit, but I can testify as to the failure of the defendant to respond to the deemed admissions.
Okay, but you're not, so the only exhibit you have is the admissions?
So far.
Okay, all right. So any objection to Exhibit 1 by Ms. Lack?
I never saw anything that said 2,900 and some odd changed. I didn't respond to it because I never saw it.
Okay. Exhibit 1 is admitted. Go ahead, Mr. Elder.
Thank you, Your Honor. We also have a business records affidavit, which would be Exhibit 2 that's been filed with the court. And I have just asked my paralegal, who is much more tech savvy than I am, to email those to Ms. Rager. I don't know if she's received them yet.
Tony, have you received those yet?
Yes.
Okay.
I would
So
have done it,
exhibit,
Your Honor, but I couldn't find my punch cards.
okay. Exhibit 2 is, any objection to Exhibit 2 by Ms. Lack?
Again, I'm not exactly sure what's on Exhibit 2. I did get one thing in the mail, but it only referred to the original debt amount on the credit card. It didn't refer to any additions.
Okay. Exhibit 2 is admitted.
Thank you, Your Honor. Plaintiff rests, Your Honor.
Ms. Lack, it's your turn. You can go ahead and present any evidence you would like, either in the form of live testimony or any exhibits you'd like to offer.
I have not sent any exhibits forward. I am in the process of filling out paperwork for bankruptcy. And again, this amount, as I understand it, is less than $7,500, which is the threshold for a misdemeanor. Also, it was 3.5 years.
Ms. Lack, this isn't a criminal case, so you're not going to be charged with a crime here. So don't worry about that.
Okay. Also, it's been 3.5 years since I was able to make payments on that card. So the debt has been abandoned for more than a 2-year period, or a total of 3.5 years. So I think that given that it has been that length of time and the amount being under the threshold of $7,500, I think it should be dismissed.
All right. I'm going to take that, unless you have an objection, Mr. Elder, as sworn testimony. Did you mean to give that as sworn testimony, Ms. Lack?
Yes.
All right, Mr. Elder, do you mind if we just treat that as sworn testimony, or do you want me to swear in and have her say it again?
No objection, Your Honor.
All right. Do you want to cross-examine Ms. Lack?
Just briefly, Your Honor.
Okay.
Ms. Lack, I'm Tim Elder and I work for the other side. Just have a few questions for you. First question is, you did open this account?
That's correct.
And you made purchases and made payments, didn't you?
That's correct.
And you stopped making payments at some point?
Approximately December of 2016.
Okay. And the account was, you received statements until the account was charged off by Citibank, didn't you?
Yes.
And the amount left on the account is $2,931.53. I'm sorry, 52 cents. Can't read my own handwriting.
That's the approximate amount. I don't remember exactly.
I'm sorry, I couldn't understand your answer there.
I said that is approximately the amount. I do not remember exactly what it was.
Okay. Nothing further, Your Honor.
Okay. Ms. Lack, did you want to provide any other sworn testimony?
No.
All right, let's go to closing arguments. Mr. Elder.
Your Honor, I do have one request. I skipped through my notes a little bit. If you could reopen the plaintiff's case so I could testify as to attorney's fees. Just so I can keep my job.
Okay. Ms. Lack, do you have any objection to that?
I mean, I can't pay any attorney's fees. If he wants to reference them, I have no objection.
Okay. You may proceed.
Thank you, Your Honor. My name is Timothy Elder. I'm an attorney licensed in Texas since 1992. I have practiced exclusively in the area of consumer debt collection since 2004. I'm familiar with the fees charged by attorneys in the North Texas area for collection cases of this sort. In my opinion, a reasonable fee for this matter would be $977.17. And now plaintiff rests.
Ms. Lack, did you want to cross-examine Mr. Elder?
No,
ask him any questions?
no, I don't want to ask any questions.
Okay. All right, let's now go to closing arguments. Mr. Elder.
Thank you, Your Honor. Your Honor, the admissions and the exhibits established that, and the testimony established that Ms. Lack opened the account, utilized the account, ceased making payments on the account, and there's the amount of $2,931.52 remaining as a balance on the account. Plaintiff asked for judgment in that amount plus attorney's fees of $977.17 and all costs of the court and post-judgment interest at the statutory rate.
Ms. Lack?
What is that amount of the post-judgment interest?
The post-judgment interest will be at 5%.
So what are you asking me to make closing arguments? Was that the question?
Yes, I'm so sorry. Yes, you'll need to make closing arguments at this time if you'd like to.
Well, as I stated previously, this debt was abandoned 3.5 years ago, and I have been unable to make payments. I'm only partially employed. I only work 15 hours a week. I make less than $9 an hour. So I'm unable to make payments. Also, this amount is considered, I think, it's less than $7,500, so it's considered a misdemeanor amount or something like that. So anyway, because the amount is considered small and it has been abandoned for 3.5 years, I would like to request that the case be dismissed.
All right, is that it, Ms. Lack? Do you have anything else?
Was that a question?
Yeah, do you have anything else, Ms. Lack?
No.
All right, the court, just so you kind of understand, Ms. Lack, this isn't a criminal case, so there isn't going to be a misdemeanor or a felony against you. This is a civil case. The statute of limitations on these types of cases are 4 years, not 2 years. So you may have heard that in like personal injury cases, they are 2 years. And it's 2 years from the date of filing. It's not 2 years from the date of trial, or 4 years from the date of filing, not the date of trial. So the statute of limitations, I think you were trying to argue, would be not applicable in this case. The court will enter judgment as requested by the plaintiff. If you do enter bankruptcy, that's something you should raise with the bankruptcy court, obviously. I would urge you to try to work something out with the other side if you can, but I understand a lot of people are going through tough times right now. And so, do what you can to try to pay this judgment, but, and that'll be it. Mr. Elder, have you submitted a judgment for the court to review?
We have not, Your Honor. Will you file one this afternoon?
Go ahead and email my court coordinator as well, Rhonda Pinson. And Ms. Slack, I hope you stay safe and good luck with your future endeavors, okay?
Thank you.
All right, thank you guys. You both are excused. Just make sure you give me the judgment this afternoon, Mr. Elder.
Thank you, Your Honor.
Thank you. All right, you guys are excused. So we actually had a trial. Let me see.
Judge, you're still on YouTube.